Let me backtrack for a second. In 2021, the NCAA lost a case at the Supreme Court, and basically the result of that loss was they realized they were going to be subject to antitrust laws just like all other corporations are.
Other than baseball.
Yes, there's no special exception. They did acknowledge the baseball exception, but they basically said if you want one of those, you have to go to Congress, NCAA, if you want a special
Except for
carve-out.
baseball, which never had to go to Congress.
Yes. There's a 1970s case, I think, that says baseball is just different. Professional baseball gets a special carve-out. No one else does.
Including, I'll add, we did a few months ago, Puerto Rican Baseball League also gets that exception, even though it's not Major League Baseball. When is a forfeiture case actually over? And what is the rule of reason when it comes to recruiting a safety for a college football team? We tackle these metaphysical questions this week here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Tuesday, December 2nd, 2025, and I have two of my colleagues here today from the Institute for Justice to discuss these issues. One of them, forfeiture, civil forfeiture, is something we have delved into many times. We got another lawsuit that'll make your blood boil, and I hope you will enjoy that from our friend Dan Alban. And also something to do with antitrust and the NCAA, two things that lots of people enjoy disliking. And so we'll get to that a little later in the show. We'll start with the forfeiture case. But first, we're going to bring on a first-timer who will be discussing the NCAA case a little later, and that is McCarley Maddock. So McCarley has just joined us recently here at the Institute for Justice. She is a grad of Notre Dame, and we will hear more about what relevance that has later on. She's also a grad of Duke Law School, where I met her a few years ago when she was a law student, and I visited there. And she has done all kinds of other things. She is now litigating for us, and she also had a history degree while she was at Notre Dame with a minor in constitutional studies. And so you were telling me, McCarley, basically the constitutional studies was an excuse to do more history. Am I getting that right?
Yeah, for me, it was an excuse to do more history with a little bit of political science mixed in. And it's all my favorite history because it's just America's constitutional history. So in my favorite class, we reenacted the Constitutional Convention, and we were each given a founder. And for the entire semester, we were that founder in our class's Constitutional Convention.
And who were you?
I was James Madison.
Oh. So, would people refer to you as, I mean, it must have been a little awkward, but the father of the Constitution then, like, during the course of the class?
There was a debate in the class over who got that title, but I think it's pretty consensus that it belonged to me. But nobody called me that at the convention.
So there is this argument, right, that actually James Wilson had much more to do with the text than people have admitted, and there's some new research that's comes out about that. Do you take a stand, or are you kind of biased at this point?
I feel like I'm a little biased. After you've been somebody, it's easiest to say that at least in our Constitutional Convention, I felt like I earned the title.
Well, maybe things played out a little differently there, but we'll get to your academic experience, why it's relevant to your case, a little bit later. But first, we're going to bring on Dan Alban. Dan is an expert at so many things. He has so much knowledge, but today he's going to discuss one of the areas at the core of his work here at IJ, and that is civil forfeiture. And we have a case here that it's not a very long opinion. It doesn't go into too much detail about what's going on, but you can tell there's a lot lurking underneath, and that is this case over a lot of money that just kind of went away, and then the government wanted to say, I guess, oopsies and just walk away from everything. But it's not going to be able to do that. And why is that, Dan?
Yeah, well, it's because the government, made a mess, pretended like it had cleaned it up, but there was still mess on the ground, and they hadn't really cleaned things up, and the court said, nope, you still got to keep going. So this case is California Palms versus United States. It's out of the Sixth Circuit. And for those of you who are perceptive, you know that California is not in the Sixth Circuit. So California Palms is, of course, a rehabilitation center located in Ohio, probably because Ohio Palms isn't quite as good of a selling point.
Yeah, I don't think I'd stay there.
Yeah. So California Palms, nonetheless, located in Ohio, had an FBI raid in October of 2021 based on a warrant or series of warrants issued by a magistrate judge ex parte, meaning without the knowledge of the facility itself or the owner of the facility, Sebastian Rucci. And the FBI executed these warrants and seized over $600,000 from this rehab facility. The reasons are unknown even really still today. And as you noted earlier, there's a lot of kind of gaps and sort of fill in the blanks that you have to maybe draw your own conclusions about what has happened. But the long and short of it is, 3 years later, the government agreed to return all of the property. It never filed any criminal charges. It never prosecuted either Rucci or sought any kind of criminal judgment against the center itself. And it tried to say, oh, no harm, no foul. And the reason I wanted to highlight this case is because it really exemplifies the abuses that are at the heart of civil forfeiture, even when someone theoretically wins. Rucci and the center got all of their money back. It's $603,902.89, which is probably either what was in their bank account or what they kept in the safe or something, or some combination of the two. It was probably the entire operating expenses of this center. And in all likelihood, it wasn't able to continue operating after this seizure, but we don't really know for sure. All of their money was seized and held for over 3 years without any criminal charges being filed, without anyone, of course, being convicted of any crime, and without any judgment that the property would be forfeited. And so the lives of Sebastian Rucci and his employees and anyone else affiliated with the center, including the people who are there receiving treatment, was altered irreversibly by what the FBI did. And at the end of the day, the FBI and the U.S. Attorney's Office representing them basically said, never mind, we're not really going to forfeit this property after all. And so it tries to make the case go away. But what had happened in the interim is shortly after the seizure, Rucci and California Palms filed a separate lawsuit seeking the return of the property and also seeking copies of the warrant affidavits that supported this ex parte warrant issued by the magistrate judge. And as is very typical in forfeiture cases, once the government realizes it doesn't have a case, and that seems exactly like what happened here. This is a classic example of seize first, investigate later. They somehow got some information, apparently from either the Ohio Department of Mental Health and Addiction Services or the Ohio Department of Medicaid. FBI got some information that led them to seek a warrant, investigated for 3 years after seizing the money, and then decided, never mind. And so
how did they bring the actual their lawsuit?
Yeah, so California Palms and Rucci, their property was seized in October. In November of that same year, they filed this lawsuit seeking the return of property, a separate lawsuit, a civil action in the Northern District of Ohio. And there's a way to do that under either the inherent equitable powers of the court in the district where the property is seized, or under Criminal Rule 41G, which provides for a procedure where someone can seek the return of their property after it's been seized, and try to get it back, especially in cases where the government doesn't immediately pursue forfeiture. Well, the government did, in this case, file a forfeiture complaint and try to get that initial case dismissed. It wasn't dismissed, and it was kind of just held in abeyance, I guess is probably the best way to describe what happened. And then 3 years later, the government moves to voluntarily dismiss the case. This is what the government does constantly in forfeiture cases if there's not a settlement. It will litigate the case up until it either realizes, it doesn't have a case, or, their investigation didn't turn up the incriminating things they thought it was going to. And then they try to back out and say, oh, never mind. We just want to voluntarily dismiss and give you your property back. And, too bad, so sad. And so in this instance, the government also tried to dismiss the second case, the one that was filed by Rucci and California Palms, and said, look, we've returned the property. That moots your case. There's nothing left to do. And Rucci and Palms said, no, wait, we also want copies of these warrant affidavits that supported this raid on our facility, because we think they're bogus. We think there's something in there that is incriminating either of FBI or of one of these Ohio State agencies that may have provided false information, and we have a right to those documents. And the district court dismissed that case sort of sua sponte, because the government did not file a motion to dismiss. It just said, hey, we've returned the property. The case is moot. Please get rid of this case. And so on the sort of technical procedural / merits of the case, what really happens is the Sixth Circuit panel says, well, that's not the right way of going about doing things. The district court can only, and by the way, sua sponte is Latin. I don't know what the official direct translation is, but it basically means the court does it through its own motion or through its own decision. It's not responding to a motion filed by a party. It's just doing it on its own. And so the district court judge had dismissed the case sua sponte, the second case, the one seeking the warrants, and the Sixth Circuit says, no, you can't do that. You can only dismiss a case sua sponte if you don't have subject matter jurisdiction. But that's not really what's at issue here. It's not whether there's subject matter jurisdiction. What's at issue is there really a right of action? Is there really a valid claim to be able to see the underlying warrant affidavits? And the government never filed a motion to dismiss saying there's no cause of action here. And since the government never did that, it was improper for the district court to dismiss the case.
Right.
And so that's kind of what. Go ahead.
Well, we discuss sometimes cases about standing, if you have standing to sue,
right.
And that is considered a jurisdictional question, so the court has the liberty to raise it on its own to make sure it has jurisdiction. But this is just like making an argument, fail to state a claim. That's just kind of a normal motion that a defendant would make in a lawsuit. It doesn't deprive the court of jurisdiction.
That's right. And so what's happened here is the initial civil forfeiture case was effectively mooted by the return of the property. The government is not pursuing civil forfeiture anymore. They voluntarily dismissed their action to forfeit the property, and almost certainly did so without prejudice, so that they wouldn't have to pay fees. But then at the same time, they also sought for the other case to be dismissed as moot. And the Sixth Circuit agrees it is moot as to the portion of the case seeking the return of property. But there was a second form of relief that the plaintiff sought, which was turning over these warrant affidavits. And since that hadn't happened yet, the case was not moot. It might not actually have a valid cause of action. The district court hadn't resolved that yet. But the district court had to hear from the parties on it, had to receive what would probably be a 12b6 motion, a motion to dismiss for failure to state a claim, a very standard motion that defendants file in civil cases. But the government hadn't done that yet, and so it was premature for the district court to dismiss the case. That's sort of technically what happened on the sort of procedural / substantive merits. But I think what's more interesting about the case is kind of how it demonstrates that someone who has had their property seized it takes 3 years. Their property is held that whole time. Do they get interest? Sure, but how do you live for 3 years without the operating capital for your business? How do you make a go of it? I mean, in all likelihood, and I'm just surmising based on the facts that are presented here and my knowledge of what's happened in many other cases where we've represented small businesses that have had their property seized. I mean, he either had to not make payroll or like mortgage his house a second time or something to make payroll. Probably had to close the business. I don't know. Maybe he had alternative sources of funding. But when your entire operating account is seized, that's usually a death knell for a business, even a medium-sized business. And I don't know if they continued operating or not, but it certainly would have been a tremendous financial hardship.
And no
to not
knowledge
have
about
that
how long it'll
600,000.
take. Like,
And you don't know. You don't
charged.
At the beginning of it, you don't know, oh, what I need to do is take out a 3-year loan because, eventually I'm going to get this money back. You have no idea if you're ever going to get the money back, and certainly you don't know when. And at the end of it all, the government's just like, never mind, we're just going to voluntarily dismiss. And, I think it highlights kind of the general sloppiness that the FBI engages in when seizing property from people. We, of course, had the case out in Los Angeles involving U.S. private vaults in Beverly Hills, where the FBI provided false warrants to the judge, to the magistrate, that were signed by the magistrate on false pretenses about how they were only going after the assets of certain criminals who were storing their property in these safe deposit boxes, and they weren't going to seize everybody's. Of course, they ended up seizing everybody's, and then mixed everything up, and didn't keep people's property separate, lost things. It was an entire debacle, and the point I want to make about that is that case wasn't an exception. That case is just how the FBI and, frankly, federal law enforcement generally often does business. They seize first, investigate later. If they don't find what they're looking for, they just return a sort of mixed up drawer full of stuff to you and say, sorry, no harm, no foul. And, it might be a pain when you have that happen to you as you're going through security at the airport and they just kind of give you your luggage back with everything kind of dumped in the bin. But at least you get your stuff back pretty quickly. This is 3 years later and $600,000. And I think it really underscores how serious civil forfeiture can be, and how a property owner who ultimately wins still has their life completely upended for years and years, and even now they still don't know what was the basis for any of this in the first place. And this will go back now to the district court to determine whether there really is a legitimate cause of action for releasing these warrant affidavits. And I don't actually know what that cause of action would be. It seems like they probably would need to file a FOIA request and then appeal the denial of the FOIA. It seems like there's probably some sort of administrative thing that would have to happen first. But it's years later. It's 2025. This happened 4 years ago, and they still don't even know what the basis of the raid was.
McCarley, curious what your thoughts are about the case, but also you were a clerk in a U.S. District Court, Northern District of Indiana. I'm sure you saw some forfeiture come across your judge's desk there, and maybe your experience with cases like this.
Well, my experience first on the district court was almost entirely criminal. I don't remember a civil forfeiture case. We saw a lot of criminal forfeiture, but that comes with either a guilty plea or at the end of a trial.
Right.
So that kind of solves this is why we're taking your property problem. Actually, when I came to IJ, the civil forfeiture stuff was kind of shocking to me. Just like I think it's shocking to any normal person to hear the government can just take your stuff and not tell you why. This was a new area to me. I actually didn't know a lot about it before coming to IJ, but this case kind of reinforces everything that I think is gross about it. Not only the timeline, which I have written in the margin of the case that this stuff just takes way too long, but also it's a frustrating opinion to read because there's so little information, and that's just as a reader. So I can't imagine what it's like to actually be the person whose stuff this is, because I was sitting there like, I know nothing about what happened in this case after reading these 7 pages. I don't know what the crime was. That's frustrating to me, just as someone who wants to know what happened. So I can't imagine being the plaintiff in one of these cases. And then the other question I had after reading it was, if there really is no cause of action for the warrants, then why didn't the government file a partial motion to dismiss at the beginning of this case? Because I certainly saw plenty of those on the district court. And if you really thought they didn't have a claim, why wait 3 years, 4 years afterwards to bring it up, or to not bring it up, I guess, to have the court bring it up? It just seems odd to me, if this was such an obvious dismissal ground for at least this claim, why wait till now?
Yeah, what do you think, Dan?
I am not sure. I mean, it sounds like the either the district court judge or the magistrate judge kind of set aside the second case pretty quickly, and so maybe the government sort of either forgot about it or just didn't think it was that important, figured it would sort of be resolved by whatever the outcome of the forfeiture case was, and maybe just hadn't carefully read the complaint and realized there was something there besides the demand for return of property. But the fact that that you never came across a civil forfeiture case while clerking for a judge, I think is actually really interesting, because I think it highlights sort of one of the dirty little secrets of civil forfeiture, which is almost all of it happens outside of court. Almost all of it, especially at the federal level, almost all of it happens administratively, and the cases that aren't administratively forfeited are almost all resolved by settlement. So very, very few cases go through to court. I also clerk for a U.S. district judge in D.C., and I don't recall seeing a civil forfeiture case either. And my antenna would have been up for that, and I don't remember one coming through at least our chambers while I was there. So it I think underscores the fact that a lot of this stuff is happening outside the courts. People aren't really getting a judge to review the facts and say, oh yeah, this is some kind of crime was committed here, or the property was definitely involved in crime. Instead, almost everything's being resolved by administrative forfeiture, or the government very often offers a deal, a settlement, and usually it's like a 50-50 deal, like, oh, hey, we have your $600,000, but if you want, $300,000 back tomorrow, we could just, you could walk away with that, and we'll keep the other half. And that's very commonly how a forfeiture case is resolved, especially if someone hires an attorney.
So I have a question about what else might be left with this case, and that's attorney's fees. So I know through the little forfeiture knowledge I have compared to Dan, that under the federal forfeiture statute, you can, if you're a successful party, get move for attorney's fees. But there's a split in the law as to whether, if the government just kind of gives the money back to you and dismisses the case, it can be with prejudice, it could be without prejudice, whether you can say, okay, I won the case now because I have my money back, give me attorney's fees. Whether you can do that. It seems to me this is a case where probably they're going to have an uphill battle if they file that motion, if they haven't already, or maybe they haven't filed that motion for reasons we don't know. But what's probably left to them in that regard?
Yeah, so the property itself was returned, and I'm not sure that the opinion says directly whether the interest was returned. Yeah, it does.
I think it does.
The government filed a notice indicating the funds had been returned with interest. So all the initial money, the $603,000, and the interest, that's been returned. Under CAFRA, the federal forfeiture law, there is a provision that if someone substantially prevails in their forfeiture case, if the property owner substantially prevails, that they're entitled to have their attorney's fees paid by the government. Here, that's complicated by a couple of factors. First of all, Mr. Rucci represented himself in the case. I am not. It does say he is the attorney representing California Palms and himself in this litigation. So I assume that means he is both an attorney and the party in the case. So he may still be entitled,
right? Because they're a corporate entity, so
to fees as an attorney, if he is legitimately an attorney and not
right.
just someone who's sort of appearing on their own behalf. But the other wrinkle is it depends how the case is dismissed, and I don't think the opinion makes clear whether it's dismissed with or without prejudice, and that is determinative in many circuits. The difference is if it's dismissed with prejudice, the government may never file a forfeiture case again. If it's dismissed without prejudice, the government could theoretically come back and seek forfeiture again within the statute of limitations, which is usually a number of years, and potentially try to forfeit the property. Some courts have seized on that as the dividing line between whether you have substantially prevailed or not substantially prevailed, and have said you only substantially prevail if your case is dismissed with prejudice, because otherwise you haven't really obtained a final judgment that secures your property forever and always. That doesn't make a ton of sense, because if your property was seized and you got it back, you've definitely substantially prevailed. You've got the only thing you were trying to get out of the case. And so, some courts have said, well, actually, it would really prejudice a property owner to dismiss their case without prejudice, because that would deprive them of their attorney's fees under this interpretation of the fee shifting provision. And so there's still litigation out there in the federal courts about this. We recently won a decision in Atlanta in the 11th Circuit where our client Brian Moore Jr. Had his case dismissed with prejudice, and the district court nonetheless said he was not entitled to attorney's fees because he hadn't prevailed on the merits, which is not part of the standard. The standard is just, did you substantially prevail or not? And so that decision was reversed by the 11th Circuit, ordering his fees to be paid. But we still have some ongoing litigation, including in Crystal Starling's case, about whether someone is entitled to fees and has substantially prevailed in a case where the case is dismissed without prejudice. So it's a big mess out there, but the long and short of it is that it's very hard for property owners to actually get fully reimbursed because of this rather ridiculous reading of the fee-shifting statute that many courts apply, saying you don't substantially prevail even when you've received all of your money back. That I don't think is what Congress intended, and it certainly imposes a great injustice on property owners.
And a footnote to all that, I looked him up. Sebastian Rucci is indeed a practicing attorney. He has his own law office, and one of the things he specializes in is forfeiture.
I bet he does now.
In this case, yeah, he does now, but he does a few other things too. So we'll see what happens to him and his case on remand. So now we're going to move from forfeiture to something not terribly related, but it has to do with lots of money, and that is NCAA and the NCAA and antitrust law, and more specifically, the transfer portal in junior colleges. So I know we have sports fans who listen. We have some fans who just don't care about sports, especially college sports. Maybe they're tuning out at this point. Stay with us, because this is super interesting, whatever you think about college sports and what is going on in colleges right now in the wake of being subject to our antitrust laws, which the Supreme Court opened the door to a few years ago. And so we're going to get McCarley's thoughts on this with her completely non-biased in favor of Notre Dame viewpoint.
Yes, well, Notre Dame did get a shout out in Justice Kavanaugh's concurrence in the NCAA case, so just have to make that plug. So this is the story of Jet Elad. His college career kind of spans the entire NCAA antitrust battle, so in a way he's a really good way to look at this. So he
never went to Notre Dame, though. I should make that clear.
He didn't, but I think I can let that go for the point of the case. So he starts in 2019 at Ohio, and he plays a couple years there. He redshirts. He has a bad year with an injury. He testifies later that he wasn't really ready to be a fully Division I athlete at the top level. So he ends up trying to transfer out after that bad year in 2021, and he doesn't get any offers out of the transfer portal. So what he does is what players pretty commonly do. He goes to what's called a junior college. That's not a full program that you would see on TV, but it's a good place for players to kind of continue their education and development. And then they oftentimes will do what Jet did, which is after a year at the junior college, he then had 7 Division I offers after that. So he goes back to Division I, and he plays at UNLV for a couple years, and he does really well at the University of Nevada, Las Vegas. He's a defensive player. He has great stats. He's actually a finalist for Best Collegiate Football Athlete from Canada. There's some award for that. So he's doing really well. And at the end of the 2024 season, he has to make this decision. Do I go to the NFL or do I play in college another year? Let me backtrack for a second. In 2021, the NCAA lost a case at the Supreme Court, and basically the result of that loss was they realized they were going to be subject to antitrust laws just like all other corporations are.
Other than baseball.
Yes, there's no special exception. They did acknowledge the baseball exception, but they basically said if you want one of those, you have to go to Congress, NCAA, if you want a special
Except for
carve-out.
baseball, which never had to go to Congress.
Yes. There's a 1970s case, I think, that says baseball is just different. Professional baseball gets a special carve-out. No one else does.
Including, I'll add, we did a few months ago, Puerto Rican Baseball League also gets that exception, even though it's not Major League Baseball. So we'll put a link in the show notes to that episode if anyone wants to go back to it.
So the NCAA does not get the special baseball carve-out. Its rules are subject to antitrust laws, which basically means that if they're commercial restraints, they have to pass what's called the rule of reason. So that rule now applies after the decision in 2021 to NCAA compensation rules, so basically what schools can give athletes in return for their services. But Justice Kavanaugh writes this concurrence in the NCAA case in 2021 that basically says, heads up, NCAA, we only decided this one rule, but you should know our decision is not, the logic of our decision is not limited to this one rule. And so that started a cascade of lawsuits from athletes challenging all kinds of NCAA rules because some people think the NCAA is as tyrannical as government officials can sometimes be. Although I'm not voicing an opinion on that, just a view of some people. So all the NCAA rules start to get challenged. The one at issue in this case is what's called the JUCO rule. That's what the district court calls it. It's basically a combination of a few rules. So first, the NCAA says if you want to play an NCAA sport, any sport, this is not just related to football, then you basically have 4 years of eligibility. You can play 4 seasons. And that has to be completed in 5 years. So you have a
and
specific
by play, you mean like go into a contest, not be on a practice field.
I think so.
Yeah, because that's like a red shirt, right? Because the first year you practice, but you don't actually go on the field, and then it's
right. And the Jet Elad actually does red shirt, but I think the red shirt might be why it's a 5-year rule. You have 5 years to do it.
Right.
But 4 years of actual competition, you're participating. And important for this case, those years can be spent at a junior college. So any years you play at a junior college count for your eligibility total. So what that means is basically you don't get to play 4 years at a D1 school if you choose to go to, and if you don't get to play, sorry. So many rules. You only have 4 years of eligibility no matter where you play. So if you play 1 year at a junior college and 3 years at a D1 school, that counts as 4 years. If you play 1 year at a Division III school and 3 years, basically you just get 4 years. Then these lawsuits started that said, well, junior colleges are really different than the Division I experience. If you go to certain prep schools, that doesn't count towards your 4 years. So we don't think, these athletes started saying, we don't think that the spending 1 year at a junior college or 2 years at a junior college should count towards our 4 years of eligibility. You have to let us play. And they started bringing lawsuits. And there's a really prominent player right now, the quarterback at Vanderbilt, Diego Pavia, wins his case, and it's like the first big case that comes down that says, no, your time at junior college doesn't count. It's just a preliminary injunction, but the fact that he won that preliminary injunction results in a waiver for a bunch of athletes, where the NCAA just says, in situations like this, maybe we'll let you play, actually. But it's a little unclear. So Jet thinks, I have another year of college eligibility based on the Pavia case, which it comes out of Tennessee. And so he transfers to Rutgers, and Rutgers, to get him to transfer, says, we'll pay you, or not Rutgers directly, but he gets a name, image, and likeness deal worth over $500,000. So
Not
big
bad.
incentive to play in college again. And he testifies later that this is a life-changing amount of money for him and his family. And $500,000 would be life-changing to anybody, but especially to someone who's
Right.
in their early 20s. That's big incentive to go to Rutgers. On top of that, Rutgers is a Big Ten school. He's going to get NFL attention, more likely from a Big Ten school. So there's a lot of good that can come out of him going to Rutgers. So he makes the decision thinking, I can play another year. Rutgers requests an NCAA waiver on his behalf, just to, I think, to make sure everything's in the clear, you're all good. And the NCAA denies it. And so they go through an internal review process with the NCAA, and he files a lawsuit in New Jersey District Court seeking a preliminary injunction that will allow him to play for the season. And the district court finds a couple things and issues the PI. First, they find that the JUCO rule is a commercial restriction, basically has economic impact. It's restricting labor entry into the market. So he has a likelihood of success on the merits with that. That's kind of a threshold inquiry. Then the district court finds that this is all preliminary, I should say. So he's asking for a preliminary injunction. So he just has to prove that he has a likelihood of success on the merits. He doesn't actually have to win. But the district court finds that there is a substantial anti-competitive effect. It finds that the NCAA doesn't have the necessary pro-competitive rationale. And so what that means is the district court finds that it's likely that the NCAA has violated what's called the Sherman Act, which comes out of the Gilded Age when there were all the railroad tycoons and robber barons. There's a show on HBO that I love, HBO Max, the Gilded Age. That's the kind of people this statute comes out of. But now people are using it to try and play football another year. And then the district court moves on to, well, will he be irreparably harmed if we don't let him play? And the preliminary injunction analysis requires a plaintiff to show that they're going to be irreparably harmed if this injunction isn't entered. So the district court says, well, the NIL money could be made up, but there are so many intangibles basically to playing. He's going to make memories. He's going to improve as a player. He's going to have a shot at the NFL. He's going to get the Big Ten experience. No amount of money could make up for missing this season of football. So he's definitely shown irreparable injury. And then the district court says, well, the NCAA won't really be harmed by this one player coming in. He will be harmed. He's shown a likelihood of success on the merits. And so the district court enters an injunction and says, NCAA, you can't enforce this rule against Jet, Elad, and Rutgers. He gets to play for the season. And so the NCAA appeals, and Jet and Rutgers make it 11 games into the season, and he plays, and he has a great season. At one point, he's leading the team in tackles. He has a block punt. He has a fumble recovery. He's killing it, basically. And then on the 11th week of the season, before the very last game, the Third Circuit issues this opinion, and the Third Circuit reverses and says the injunction should not have been granted.
And that was on November 25th.
Right.
Add. Right, which was like 2 days before Thanksgiving, I think. And their last game was right after Thanksgiving.
Right. So this comes down on Tuesday. The last game of the season is on Saturday. Great timing, Third Circuit. So the Third Circuit basically doesn't do the full inquiry of the district court. It thinks some different things about threshold issues. So the NCAA basically challenges everything, and the Third Circuit says we only need to address a couple arguments. And first, the NCAA says this rule isn't commercial. The JUCO rule has nothing to do with commercial activity, so the Sherman Act just doesn't apply. And they're relying on this really decades-old precedent about a different NCAA rule that was way before the Supreme Court's decision in 2021 called Smith. And the NCAA basically says this isn't commercial. The 2021 decision didn't change too much, so this eligibility rules still aren't commercial, period. And the Third Circuit politely says that's ridiculous under Supreme Court precedent, I think. And they basically say, we're talking about a different world than that precedent was in. We're now talking about a world in which players are being paid, $500,000 to come play. This is a huge labor restriction. And there's no way to say this isn't commercial anymore. There's just so much money going on. This is $1 billion industry for these colleges. The idea that you're both restricting labor and preventing these players from making this kind of money, this is commercial. There's no way around it. Then the NCAA says, fine, it's commercial, but they didn't define the market. And defining the market is really important in these antitrust cases because it's such a factual analysis that you really have to get into the nitty-gritty of what's going on and the statistics and the econ numbers that are all way over my head. But it's part of the antitrust analysis to get deep in the weeds on these factual realities. And the problem after the Supreme Court's 2021 decision is that those realities are just constantly changing in this college football environment. NIL is new. Ways of dealing with NIL are new. Eligibility rules are changing. Injunctions are being issued and denied. So we're just in a world where no one really knows what the lay of the land is. But even if it was a stable environment, the Third Circuit says the district court just didn't do the necessary analysis. The plaintiff didn't meet their burden to define that market. And the plaintiff basically came in with an expert who said, look, this is what the Supreme Court said the market was in 2021. It's the market for Division I football players. That may have been true in 2021. It wasn't really litigated in the Supreme Court case, but the Third Circuit says you absolutely do need to litigate it in this case, and you can't just rely on what was going on in 2021 because the market has changed so much in the last 4 years. We need real-world evidence. We need statistics. We need your expert to have done a much more thorough analysis, and he just didn't do it.
Yeah, it's kind of crazy. You needed the Supreme Court case to kind of open the door to antitrust, but then that created a whole new world where everything before it didn't apply to this new way of using antitrust.
Yeah, so it's a really interesting environment we're in where everything is unstable kind of because of legal action, but you need to have defined a stable, precise market for the legal challenges to work. There was a case in the Sixth Circuit where Judge Lepar had a really interesting concurrence just talking about all the questions that have come up and what evidence would be helpful and what evidence would be helpful for plaintiffs to present in the future, but it's kind of like we just all need more information right now. But the Third Circuit says you didn't present that information, so the injunction shouldn't have been granted. It was your burden to show the market. You didn't do that. We're not even going to get to the rule of reason. This goes back down. So it would go back down to the district court, but like I said, we're on this really, really tight time crunch. So what ends up happening is the district court issues a TRO that lets him play on Saturday in the final game against Penn State. He has a season-high 11 tackles, but unfortunately they lose the game, so his season is over. And I guess to kind of come full circle, my guess is that moots the case the way the first case was mooted because there won't be an issue anymore.
Because he's not suing for damages or that kind of
right.
thing.
He just wanted to be able to play. And so he got to play even though the Third Circuit reversed the injunction.
So this gets really in the weeds, but why would he need a TRO? Because I assume that the PI wouldn't apply, doesn't go away until the mandate is issued from the court, and that wouldn't be till, more than a couple days later.
So I looked at the docket, and it looked like the mandate issued, and then the district court, from what I could tell, issued a show cause order for why this should be enforced. And
Oh,
then
wow. So they issued the mandate right away.
It was pretty quick. I think
Wow.
they finally understood there was some urgency here, I guess.
Yeah.
But so he gets a TRO. It looked like the NCAA tried to appeal the TRO, and that doesn't work. So he got to play.
As we know from some other proceedings recently, you can't appeal TROs, but you can if they're actually PIs.
But so he got to play, but there's going to be all kinds of questions, I think, as this keeps going for someone who maybe isn't on literally the last week of their season when the decision comes down.
Dan, I know you don't care too much about college football, but you do have some thoughts about wrestling.
I do. Everything that's gone down with these NIL deals and sort of the reshaping of college sports has dramatically affected wrestling. A number of wrestlers from small schools have gotten similarly lucrative offers from the big schools like Iowa and Penn State and Oklahoma State, and have had life-changing amounts of money thrown at them, and often come from junior colleges, or currently the University of Iowa has a D3 national champion, two-time national champion, or maybe three-time national champion, who's wrestling for them in his final year as a D1 wrestler. So it's interesting to see how this is affecting all kinds of different sports, not just the showcase sports like football or basketball, but also smaller sports like wrestling, which really aren't revenue generating sports for most colleges. Nonetheless, boosters who really, really want their team to win are throwing crazy amounts of money at these college kids who have never seen those kinds of amounts of money before, and I think it's still shaking out how that's going to affect the league. It certainly benefits those wrestlers. It seems to be at the detriment of a lot of the smaller schools that essentially develop a good young prospect, turn him into a star, and then immediately he gets sort of bought out from underneath them. Very much like pro sports. And so I think obviously the effect of all this is kind of to turn NCAA sports into something much more like pro sports. I think in some ways that's a shame, because I think what a lot of people like about college sports is sort of the fact that underdogs maybe have a better chance. That underdogs win more. It's not all about the money. At the same time, it clearly is something much more akin to pro sports, with the amount of money that's thrown at it and the amount of money that each school in the NCAA stands to make from it. And so, I think that the athletes themselves certainly should be able to enjoy some of the fruits of that. And perhaps we can return to having something more like D3 sports that are kind of outside of the outside of everyone playing for NIL type deals, and are actually genuine student athletes as opposed to pro athletes who happen to go to class every now and again.
I think it'll be really interesting too when these rule of reason, when they actually make it to the merits. A lot of these cases have been mooted because one of the arguments is that you're hurting the junior colleges because they're losing students who would have gone to junior college, but no, it's going to count against their eligibility. But I think there are really open questions and kind of dueling narratives about that and what it actually does to these schools. And I think there's like over 300 Division I schools. So when most of them, I would imagine, aren't making revenue off sports either. It's really a top set that make any money off sports at all.
And if they are, it's probably just a couple sports, right? If anything.
Yeah, it's usually just football and basketball, and a handful of schools are known for some other sport that makes them money. But those sports make them tons of money, and that's why the college football coach in many universities is the top paid employee in the school.
Yeah, and the top paid public employee for state schools.
Sometimes for the whole state, yeah.
Many states. Yes.
Yeah. Well, in part, that's just because the governor's salary is capped at something politically appropriately low that doesn't get the voters outraged.
Right, but you wouldn't want to do that for the football team.
Of course not. No.
Well, this is crazy how fast it is changing. I have trouble keeping up. I mean, I follow college sports a good bit, but I have trouble following how all these rules are working. I usually rely on my 12-year-old son for some of the details about that. But I bet if we do a case like this in a year or two, the market that this expert is, if this case had gone forward, is going to look at would be very different. And so we'd maybe be having a different conversation. So it'll be interesting to watch that. One other thing that's interesting is I saw on the lawyers. So the NCAA had, as you might imagine, some pretty high-powered lawyers in this appeal. One of them is Dan Epps, our friend Dan Epps, who was part of the Divided Argument podcast and been on Short Circuit in the past. So he seemed to put in some value for his client there, even if it was a little 11th hour how the court ruled on things. So we'll keep watching Dan's cases and other cases as well, including the forfeiture case that our own Dan Alban talked about earlier. So thank you both for coming on and doing a little forfeiture, a little college sports. Thank you all for joining us. And please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.